Subscribe to our channel and press the bell icon to never miss an update. Join the only official Telegram channel of RAU'S IAS Study Circle to get relevant material and important updates. Hello everyone and welcome to Daily News Simplified, your one-stop solution to detailed analysis of current affairs which are published in the Delhi edition of the Hindu newspaper. Articles dated 14th of May 2021 which are put up for today's discussion are listed on your screen. And the time stamping for the same is given in the description box. So let us start with the first article itself.
Now all of us understand the importance of optional subject in overall scheme of UPSC Civil Services examination. And if you're confused about which optional subject to choose, how to find the best teachers and academic support for your optional papers, and above all, how to prepare for the same during these difficult times, RAU'S IAS has best solution for your optional subject related problems. We are conducting optional orientation sessions on 22nd and 29th of May 2021, in which you can learn from the RAU'S IAS teachers about how to prepare for the optional subjects and how are we going to help you in scoring your best in the mains examination. The optional batches are starting from 4th of June 2021 via live online classes. Consider this as a call to all of those who wish to completely cover the optional subject by December 2021. This will ensure timely coverage of optional subject, and then you can focus your attention completely on prelims from January or February 2022 and keep revising the optional subject till you appear for the mains examination. RAU'S IAS is offering guidance for political science, public administration, history, sociology, geography, economics and psychology from Delhi, Jaipur and Bangalore centers. In the description of the video, there is a link which you can use to register yourself for the orientation for the respective optional subject session. We at RAU'S IAS are committed to give you the best guidance and academic support to excel in civil services examination. Join the orientation and kickstart your mains optional subject preparation from a team of best teachers in the arena. Let us now begin the discussion.
So the first article in the discussion lineup is related to the medical education in the country, the lack of doctors and lack of other staff related to the medical field. The author in the article has argued that privatization of the medical education cannot provide a long-term solution to the current crisis. Because of this crisis, there is a lack of medical equipments across the nation. You must have seen about them in the news as well, related to the oxygen providing, related to the vaccination, related to the other drugs important. However, beyond that, we also require a good amount or a large number of man-force related to the doctors, paramedics and the related staff. As per the article, the current situation says that there is a shortage of health workers, especially the doctors in the northern states such as Punjab, Haryana, Uttar Pradesh, Rajasthan, and in fact, Union Territory of Delhi. There is also ethical standards of the medical practitioners going questionable. You must have read about certain news where private hospitals are charging the exorbitant or a very high prices to the patients who have been approaching these hospitals. The another issue which is being faced by the nation as of now is lack of adequate staff. You must have also been observing that number of government hospitals are not equipped in order to provide the long-term stay of the patients. Most of the times patients are being either going OPD or they are being referred to the other private hospitals. In fact, some of the private hospitals have also denied entry to the eligible patients. This is not only putting the pressure on the existing system, but it is also providing crunch of the medical services and right to health to those people who are not infected by the viral disease. However, they also require accessibility to the hospitals. In fact, there are millions of other patients who are also trying to access the medical services. These patients include patients from the case. These people include patients of cancer, HIV, tuberculosis, trauma cases, and many others. The majority part of the article is based on the last point, that is privatization of the hospitals as well as the education, especially the medical education. In previous instance, what we have observed that Niti Aayog has proposed to allow private entities or maybe private companies or the corporate sectors to take over the district hospitals for converting them into teaching hospitals with at least 150 seats. Now, what does this proposal simply mean? It means that there is a district hospital in the country. Every district has that particular government hospital. They all have basic facilities, including the primary, secondary, and tertiary services for the health. However, they do not have medical teaching facility as such. So what Niti Aayog has provided that they have said in a report that these district hospitals should also act as medical colleges and should provide basic MBBS degree to newcomers or the new students aspiring to get into the medical field. However, privatization of the medical education, as per the author of this article, can go in the negative direction because it may lead to what he has argued a corporatization and the profit orientation of the education. This will restrict the people who are poor in the society, however, want to be doctors in the near future. Apart from this, it will also restrict students who are coming from the rural background but are aspiring to become a medical practitioner. With this, the author has also provided a kind of way forward in the article itself, and the author has said that the public funding of the private operated hospitals could be taken up. There is no point of denying it altogether. However, a good regulation is required for these hospitals. For instance, what government can do, they can regularize the fees. They can also regularize the number of seats. So through these regulations, government can actually bring out a level playing field as far as private participation in the medical education is concerned. Apart from this, author has also argued that government can increase the intake of the students in the medical college, which simply means they can increase the number of seats. Next is that government should allocate adequate financial resources to the medical colleges, including the financial resources to bring out or to buy new equipments, new technologies in order to train the students in the best technologies available at the global level. And the last point argued by the author is improving the quality of education to paramedics as well as the supporting staff. Well, this is something where we need to focus upon. If paramedics and the supporting staff are equipped enough, they can provide basic services without the availability of the doctors as such. They can provide the vaccination program. They can also provide basic prescriptions. They can take on the institutional delivery program, so on and so forth. So providing these kind of people highest level of capacity building through better education can also release the pressure in the primary healthcare services. The next article in the discussion lineup is related to a recent application filed by Assam's National Register for Citizen Authority in the Supreme Court. The authority has asked for re-verification of its citizens list. Why? Because the authority is apprehensive of various irregularities in the counting process as well as the data collection. The context of the article says that Assam National Register of Citizen, that is NRC, authority has approached the Supreme Court for seeking comprehensive and time-bound re-verification of citizens list, highlighting major irregularities in the process. The second demand was the revision of the draft NRC because as of now the NRC has not been finalized. So they are demanding the revision of the NRC and also supplementary list under a relevant clause of the schedule of citizenship, registration of citizens and issue of national identity card rules 2003. Well, these rules were passed on the sidelines of the amendment in the Citizenship Act 1955. So what the authority is demanding that there should be a revision of the draft NRC and its supplementary list. So there were certain supplementary lists which were added to the NRC after the final exercise, and the authority is demanding to go for a revision in those lists as well as the original draft. And third, the authority is saying that there should be a deletion of illegal voters from Assam's electoral roll. While this is a matter of concern because illegal voter here does not mean that they are not the people as such. Illegal voter means they are the voters in the wrong place, or maybe they are not the citizens of India altogether. So they may be a foreigner, they may be illegal immigrants, and they are entitled or they are getting entitlement to vote in the elections. And once they are getting such kind of entitlement, it is easier for them to get a original citizenship documents. Now, apart from the news itself, we should know some basics about what NRC is. Well, NRC is a National Register for Citizen, and citizen means those who are eligible under the Constitution of India. And the law made by the Parliament under Constitution of India to define the citizenship in India is Citizenship Act 1955 and its consequent amendments. These amendments actually define that who is eligible to be the citizen of India. There are 5 conditions for that. However, we will keep it out of the discussion because we are not getting into the Indian polity as such. NRC deals with the official record of those who are legal Indian citizens. It means it is an official record maintained by the government and not by any other irregular NGO or a private entity. This register includes the demographic information, not the biometric, so you should keep this in mind, about all those individuals who qualify as citizens of India as per the Citizenship Act 1955. If you have read about the Indian polity and a brief history of citizenship in India, you will come across that all the provisions which are mentioned in the constitution are talking about those people who are eligible to be the citizen of India till 1950 January. It means anyone who is looking to get the citizenship of India beyond this date will be categorized, will be qualified under a separate law made by the parliament. Why parliament? Because if we allow the state government to make citizenship as their qualification, what will happen? Each state will make different rules and India will no longer have a unified single citizenship in the country. And this is the reason why parliament is allowed to make a citizenship act and not states. NRC was introduced after 1951 census of India and Assam was the first in updating the NRC. Now what is this updating? Why other states are not updating? Are they still following the age old data? Are they not having anything new in the context? Well, the answer is very simple. Take for example, in 1950 there was Mr. X. And what happened? He was the citizen of India. Mr. X had two sons, Y and Z. And consequently, each of them had two different sons, and so on and so forth. The entire process kept on multiplying with every generation. And now, in the family of Mr. X, there are more than 20 people. Now, as per the NRC, Mr. X was citizen, but 1955 Act of Citizenship defines that descendants of X who are born in India will become the Indian citizen on registration because of their birth. So, citizenship by birth is allowed in India. So, all the people who are part of Mr. X family are now the citizen of India automatically. So, there is no need to update the data under NRC at all. So, they will be included in the NRC one after the other. However, in the state of Assam, there was a different case. Because of 1971 India-Pakistan war, millions of migrants came to India to seek asylum. And because of this, India could not identify the real or the original habitants of the Assam and that of the illegal immigrants. And because of the ongoing civil protest in the state of Assam and a high amount of violence across the state, what happened that government of India actually allowed updating of the NRC. So what happened? Assam began updating the NRC, and Assam is the only state to do that in the country. Well, in the updation process, what happened? They included the names of the person along with the decedents whose name was successfully registered in the NRC of 1951, like all the other people in the country, including Mr. X, or was found in any of the electoral roll till the midnight of 24th of March 1971. So till this date, if you are part of the NRC or you are in the electoral rolls of Assam, you become what is known as citizen of India, and also your descendants, your children, your grandchildren and others will automatically become part of the NRC. However, all those people who could not provide authenticity of their citizenship, or in fact the citizenship of their parents and grandparents since 24th of March 1971, are those who are facing the brunt of this new rules. Now, what this updating process has done, they have excluded millions of people outside the list and they are running poll to poll in order to get their citizenship validated. The purpose for this updation was simple. As I've discussed, there was a huge wave of illegal migrants in the Assam because of the 1971 war with Pakistan. Now, going by the eligibility, that who is eligible under NRC? Well, the rules are very simple. Any person whose name has appeared in the NRC of 1972 or in any of the electoral rolls as we have discussed previously. Second is the person who has registered themselves as per the rule of central government with foreigner registration regional office. Well, these offices are situated across the nations or even in different nations where you can get yourself registered. Third being any person who had migrated to the Assam on or after the 1st January 1966 but before 25th of March 1971. These things are not as important for the examination, but you should have a basic clarity of the entire issue as such. Next is people who are original inhabitants. Now, these are the people who are demanding or who are actually raising voice against the illegal immigrants for stealing their economic prosperity and share. So, people who are original inhabitants and their children, including descendants who are citizens of India, provided their citizenship is ascertained beyond a reasonable doubt by registering authority. And the last one being the persons who can provide any of the document issued up to the midnight of 24th of March 1971. Now the real issue is what happened to those people who do not have authentic document. However, they are the descendants of the original or this people of India. Suppose this, there was a person who came to Assam in 1970. He stayed there, he worked there in a private organization. He did not had any important document to establish his citizenship. After 1971, what happened that he was able to get his authentic document in the year 1974. Now, he was an Indian, he was working there, he could not have those documents before the date. So, all his children and grandchildren will face the brunt of these kind of rules because they do not have authentic documents. And as we know, the documentation in India is not a foolproof exercise, including those documents which are filed in the online platforms. The background of the issue was started in 2013 when process of NRC update began in Assam as per the Supreme Court order. The updation was taken to wean out the cases of illegal migration from Bangladesh and other adjoining areas. NRC updation was carried out under the Citizenship Act 1955 as well as the rules framed under Assam Accord 1985. Assam Accord was signed between the Government of India and all Assam Student Union in order to bring out rules and regulation to regulate the migration as well as to send back illegal migrants from Bangladesh. However, the real issue is that even if we identify hundreds and thousands of people, will Bangladesh ever try to accept them back? Bangladesh as a nation has always denied that people have been migrating from its own soil to India. However, the ground realities are altogether different. And this kind of gesture has somehow created an international tension between both these nations, and this could not have been resolved even after a long drawn diplomatic and deliberative actions. The final draft of NRC was published in August 2019 and it has actually excluded 19 lakh people out of 3.3 crore populations for lack of adequate documents. Imagine if government itself cannot keep the documents for more than a decade, how can they expect small poor families who are migrating every year to keep those documents? So government as per the Supreme Court and many other judgments should come up with different kind of initiative in order to allow these people to make authentic claims about their citizenship. And even if we assume that these 19 lakh people are really the illegal immigrants, do India have such an infrastructure to keep them under detention? Can we provide them detention under human rights conditions? Or if we allow them to go back to the Bangladesh, will Bangladesh take them with open hand? Well, these are the issues which are attached to the consequence of the NRC as such. Lastly, the NRC or the final NRC is yet to be published by Registrar General of India. At the last of this discussion, I would like to say that those who do not know the real difference between NPR and NRC, I would like to put it very simply. National Population Register is talking about population, and National Register for Citizens only talk about citizen. Now, what is the difference? Well, difference is very simple. Population is anyone who is staying in India for more than 180 days. It could be anyone. It could be a foreign officer. It could be a citizen of Australia staying in India for about 1 year for a business thing, or maybe for a particular job. It may be a tourist. It may be a patient who is staying in India for over 180 days, or maybe likely to stay in India for 180 days. He or she is becoming part of the population. There might also be a pregnant woman who is giving a birth to a child, and because of certain complexities they cannot leave the country for next 1 year. So all these kind of people will be counted under the population. However, they are not the citizen of India. All those people who are part of the population and also the citizen of India are counted for NRC. So people who are in the NRC are already part of National Population Register. So you should have the basic difference about both these concepts. Now with this we will move to the next article. This article is related to the recent reform taken up by the higher judiciary, that is the Supreme Court of India, in terms of virtual proceeding and their accessibility. The context of the article says that Chief Justice of India N.V. Ramana has launched a mobile application to enable journalists, not citizens, not common people like you and me, but to enable journalists to report virtual proceedings without having to visit the court. What does it mean? Well, understand the concept through this example. Every journalist who is staying in India, who is part of the Indian governance process, is required to get true reports of the government functioning. And government functioning here also includes the judiciary. Now, what they do in order to report a particular incident or a particular action or an initiative of the government, they require exact report, exact data form. For what? To report it to the citizens. Now, including this article, how this article was published, because somewhere down the line a citizen was able to get this news accessible. As of now, because of the ongoing medical emergency in the country, many of the organizations are either shut down or they are not working at their full capacity. As a result, journalists are not getting the accessibility to the exact or the real information published in the different proceedings and the cases which are going on in the Supreme Court. So, in order to create a direct link between the judicial proceedings and the journalist in the country, this application was launched recently. Name of the application, how it is accessible is nothing important because you are not a journalist, you are preparing for civil services. The point which is mentioned in the article and which is relevant for you is to see that whether such kind of transparency is good for India and its governance functioning. The reason why this was launched is simple. CGI has said that initiative to launch a mobile application for journalists came after he heard that the press was depending on the lawyers for video links for virtual hearings. Now, going by a video link and that too provided by the lawyers, how can they assure that the exact information journalists are getting is authentic one? And what if lawyers try to exploit the journalist against money? So the information which journalists should get free of cost, they may get exploited or may get cheated for the same. So in order to remove all those kind of ambiguities, what they have done, they have provided a direct virtual link. Earlier in 2018 judgment, well, you can also quote this judgment, a three-judge bench headed by the CJI Deepak Mishra had given a note to live stream court proceedings saying this will bring more accountability and enhance the rule of law. Why accountability? Because everyone could access the real information without any tricks or turns. Rule of law means that rule would prevail. There will be no superiority or inferiority in the proceedings of the government or including the judiciary. I would like to quote a good example over here that if you want to go through the virtual hearing of a court, you can go through the YouTube and you can search for Gujarat High Court. Yes, Gujarat High Court actually provides online streaming of their proceedings. The other points which were highlighted by the Chief Justice of India include that transparency is a time honored principle. You cannot delay or you cannot postpone the transparency in the governance model. Hence, it is a time honored principle when it comes to the country's judicial process. So, transparency is applicable to each and every institution where people are involved. And this is one of the most important pillar of a good and healthy democracy. It's important for the public to be able to access court proceedings since the ruling of the court has bearing on the lives of the people. Take for example, what would have happened if the proceeding of a Supreme Court under Article 377 or maybe right to privacy was not made public? Because of the information which was released in the public domain, people right now know that what kind of rights they are actually enjoying and how the governance model is shifting as per the change in the time and democracy dynamics. CGI also has said that media's role assumes importance in the process of disseminating the information. As we normally say that media is the fourth pillar of the democracy. Indicative notes on Supreme Court's website would provide concise summaries of landmark judgments in easy to understand format because the judicial language or the legal language is not as comprehensive that could be understood by a normal or a common man. So what they have done, they will provide indicative notes on the landmark judgments. Take for example the Keshwan Bharti case or the Minerva Mill case or the recently Puttaswamy case. They will provide a brief notes on that. And these notes could be easily accessible, could be read and could be comprehended easily. And lastly, CGI has argued that project must be implemented in progressive, structured and phased manner with certain safeguards. Now, why he's talking about safeguards? because providing certain information in a virtual world does not mean that it is completely safe and secure. So both the parties, the one who is releasing the information and the other who is receiving the information, should have a basic or a straightforward secure environment in order to ensure that the live streaming proceeding is achieved in a holistic manner. So, with this, now we move to the other dimension of the article, that what are the pros and the cons, or what are the positives and the negative of the live streaming of the cases in the higher judiciary. Well, first we will look into the positives. The first being enhanced transparency and rule of law, which was also argued by the Chief Justice himself. It will give the accessibility to the courtroom to common citizens. As of now, we do not know how Supreme Court actually functions. What are the things which they keep in under the discussion? How they come to a conclusion? We do not know anything right now. These kind of initiatives will provide us the accessibility to those proceedings. This will also help them to understand and shape their own opinion on various matters on national concerns. So, if a Supreme Court is saying that privacy is part of your human rights, then we should know, and we should also be able to form our own opinion, not on the basis of the media reports, but on the basis of the exact words which were used by the judges. It will also empower the citizens and strengthen Article 19(1)(a) of freedom of speech and expression. It will prevent dissemination of the fake news. Of course, it will restrict the media from reporting anything which is not part of the judgments, and will not create any controversial issues as such. The indicative notes will translate tough legal languages, as they have done in their own initiative recently. They will translate these legal languages in simple communication ones and will clear out the confusion as such. And lastly, it will allow the law students, interns, as well as the young lawyers to learn by watching the actual court proceeding. I repeat, you can watch the Gujarat High Court proceedings. Most of them are recorded, but they are available on YouTube. You can watch those proceedings to get the clear cut understanding of how a higher judiciary actually works. Going by the negative aspects of live streaming, the first is lack of sufficient infrastructure. How many courts in India actually have that infrastructure to provide high definition access to the proceedings? And what proceeding are they actually talking about? Only the controversial cases or the cases which are dealing in the public domain, or will they provide other cases as well? The second is the need for additional funds from respective state governments, because judiciary legal itself is a part of the integrated system. Then the sharing of the funding itself become a matter of concern. Third being the need of additional data, especially by not well-to-do lawyers, to hear lengthy courtroom proceedings. So a poor lawyer who is not from a well-off background, how will he able to access those additional data? And data here means the virtual data. Next being the misuse of the technology, as we were talking about the safeguards and the privacy issue. The next is the live streaming of the arguments in the court can be used by the government as a platform to air their political views on serious constitutional and legal issues. So when a judge or a lawyer speak out their mind, they might be subjected to being pro or being anti to any political setup. And if they are pro to any political setup, the opposition can use those statements to fight against the ruling party. Next is non-desirable or reasonable to provide live streaming of criminal cases, which is important, or the cases of divorce or even the adoption, including those of family disputes or in fact the inheritance. All these are very sensitive and personal issues. All these cannot be live streamed. So live streaming itself comes with a limited accessibility and limited approach. And lastly, the live streaming of cases may impact the right to privacy of the citizens as enshrined by the K. S. Puttaswamy judgment. You should know the value of this judgment, which has set a precedence in the time to come as far as privacy in the country is concerned. With this, now we move to the next article for the day. So now we come to the last part of our discussion, which is the scheme of the day, which I always put up whenever I come for the DNS. The scheme for the day for today is your Pradhan Mantri Bhartiya Jan Aushadi Pariyojana. This scheme is nothing but a scheme which is run for providing generic medicine to the poor and disadvantaged people across the nation. This scheme is run under the Department of Pharmaceuticals, which is under the Ministry of Chemical and Fertilizer. You should not confuse this scheme being under the Ministry of Health, because many of the times what we try to relate a specific scheme to a specific ministry. Although this scheme is targeting the right to health, however, this scheme is not under the Ministry of Health, but it is under the Ministry of Chemical Fertilizer. Bureau of Pharma Public Sector Undertakings of India is the implementing agency of this scheme, which means the private pharma companies are not the implementing agency. So the companies like Ranbaxy or in fact the Sun Pharma are not implementing this scheme, but the government companies are. Well, this bureau will provide one time of assistance in furnishing an establishment cost of the outlet. Outlet here simply means a center from where you can get all those medicines. So this store can be set up by the assistance given through the bureau. The objective of the scheme is very simple and straightforward. This will provide quality generic medicines. So this is your first word. They will provide the generic medicines. Non-generic medicines will not be available at an affordable price. That means they are not free. To all means to all, whether you are rich, whether you are poor, you belong to APL, BPL, whether you are a woman, you are a child, you are old age, you are a PWD, no matter what, everyone will get their due share of generic medicines under this scheme. However, poor and the disadvantaged people will get preference. This scheme will be implemented throughout the country, so no specific district or a pilot project. And the medicines will be distributed through Jan Aushadi Kendra or JAS. And the major target of the scheme is to reduce the out-of-the-pocket expenditure by the citizens of the country. The background of the scheme says that Jan Aushadi is a novel project. It was launched by Government of India, so it is not a state-specific scheme, and it was launched in the year 2008. Since its launch, Pradhan Mantri Jan Aushadi Kendra were set up across the nation since November 2008. And as far as my knowledge goes, the first center was set up in Amritsar. Well, correct me if I'm wrong. I think it was set up in Amritsar in the same year. Now, going by the other pointers of the scheme, this scheme will encourage doctors to prescribe generic medicines. Of course, if you are a doctor working in the public sector hospital or a government hospital, you are required to prescribe the patient, irrespective of their income approach, the generic medicines. And it will also encourage to reduce the unit cost of treatment of the person. The state government are required to provide space, that is open property, in the government hospital. So the keyword is in, not out, in the government hospital premise or any other suitable location for running the general Aushadi stores. It means that if this is a specific government hospital of the state government, they can provide a specific location to set up Jan Aushadi stores. Apart from the state government, even the civil society with the experience of 3 years can also open Jan Aushadi store outside. So the keyword is outside the hospital premise. Now, this specificity does not say the hospital in this case should be government or the private. So civil society can also establish a Jan Aushadi Kendra outside a large private hospital. Pradhan Mantri Bhartiya Jan Aushadi Pariyojana Kendra or the stores may also be opened by any means any government agency. You can take the example of IOCL, BPCL or Hindustan Petroleum or many other public sector agency in any government building, not hospital, building owned by the government bodies. So for instance, the Department of Pharmaceutical want to establish a Jan Aushadi Kendra in a building run by Bharat Petroleum. So they will open a small center over there and they will establish a shop of Jan Aushadi Kendra to meet the demands in the locality. So a specific location is not required. These locations can also be put up for establishment of the stores. Individual entrepreneurs or the businessman, pharmacists, and in fact the doctors can also the Jan Aushadhi Kendra outside the hospital premise or any other suitable place. So there is only one entity, that is the government, be it the central or the state, which can open a Jan Aushadhi Kendra inside the hospital. All other agencies will set up it outside the hospital. So from the discussion, it is clear that who can establish the store. It could be central government or the state government. It could be a civil society or an NGO. It could be a public sector undertaking or any other government agency. And it could be a doctor, pharmacist, and lastly, it could even be a private person or an individual or a businessman. So all these can establish a Jan Aushadhi Kendra at a specific location. This scheme is not based on any assistance or subsidy from the government because the medicines are charged. They are not free of cost. So the one who is establishing these stores can make a good amount of profit through the margins. And lastly, only medicines manufactured by the central public sector undertakings were supported previously. However, now the private manufacturer of the generic medicines can also supply their product to these stores. So what we can see, the main condition is to sell generic medicines. It could be from the private manufacturer or from the public manufacturer. With this, now we move to the last part of discussion, which is the question of the day.